But this case talks about what the test is, and a lot of courts are still using the wrong test to balance it. They're saying, well, I find it's more probative than prejudicial. Not the test. The test is the probative value substantially outweighs the prejudicial effect. And you're thinking, what's the difference? For appellate attorneys, it's about 5 pages worth of, oh, I can make an argument that they didn't use the right test. But so be aware of that. And people are still talking about tacking. Tacking is gone. It's gone. All you young lawyers are like, I never heard of tacking, which is good. For you lawyers, my age, we all know about tacking. Oh, and do you recognize who I tried to get like some 70s picture. That's the boss. Oh, I'm sorry, that's not Alex. It's Bruce Springsteen. The boss. All right. Oh, this was a case where they wanted to have an expert on weapon focus effect. And that sounds kind of like, eyewitness expert, but it's a little different. And what happened in this case was they just didn't lay the proper predicate. They didn't put enough on there, and the court went on and on for pages about this soft science and this wasn't reliable. We have to separate the wheat from the chaff. If I read that one more time, I swear I'm going to put a belt around my neck. I'm kidding. All right. Okay. CCA continues their love affair with latches. They love it. And for those of you who don't do writs, latches is a way the court can say you lose even if you're so right. And the procedural history of this case is interesting. The guy was convicted like 10 years later. He's like, hey, I never got my appeal. So he does a writ for an out-of-time appeal, which the state agrees to, and the judge issues findings. Like, yeah, he should get his out-of-time appeal. They send it to the CCA. The CCA on their own motion sends it back and says, we want you to brief latches. The state didn't even raise latches, okay? But the CCA is like, oh no, this is our perfect case because he was resting on his rights. He wasn't moving fast enough because, in prison it's a full-blown Westlaw Lexis library going on. He knew all about it. So, for those of you who do writs, latches, it's a fearful thing. This makes me so mad, especially when the state doesn't raise it. And on a direct appeal, that's just record evidence. I mean, it's not like the state can't get witnesses back. I mean, it's a record. I guess what they're afraid of is if you win, which would be a miracle, then how would they try the case? All right. This case is Stan and Casey's Ex parte de la Cruz. And basically, they found out a bunch of evidence was wrong, and there was false evidence about where the body had been shot. There was a lot of evidence in this case, and the court said, yeah, but we don't care. He's still, conviction's affirmed. So, false evidence wasn't really material, because the jury doesn't need to know everything, just enough to convict. All right. This actually was a pretty good case, and this guy, he had 2 convictions, and they were stacked. Well, he won a writ on one of them, and the court didn't restack. And the state's like, whoa, you're supposed to restack. And the CCA said, no, once the old judgment's gone, that stacking order's gone. So for those of you who have 2 cases and were fortunate enough to win a writ that was stacked, you've got some good law to rely on. In the next, if you get that in the next 10 years, that would be great. All right. Oh, and this case is another case with really bad facts that have really hurt the law. I'm not kidding you. So the guy's charged with some offense. It's a state jail, but they agree not to indict and let him plead to a misdemeanor, and he waives the statute of limitations on this plea because they're allowing him to plead to the lesser. Then, of course, what does he do? He files a writ saying, oh, well, this was outside the statute of limitations. It's like, dude, stop. You're killing the law. So they overturned a case Judge Cochran wrote in 2011, which was a great case about statute of limitations and it's a substantial right and all that, saying, well, you waived it, and we're not even sure if statute of limitations on its face anymore is reversible. So the old case is Phillips, but anyway, that guy should not have been doing a writ on a misdemeanor to screw up our law. If I saw him myself, I would tell him. All right. This is the only Fifth Circuit case I have, and it's a pretty good case for those of you who have ever pled someone guilty. I don't know about you. Maybe that happens once or twice in your career. But just merely telling them that you're likely to be deported, a judge's statement that they're likely to be deported is not dispositive of whether the lawyer informed him of his immigration consequences. So it used to be, or a lot of people like to say, well, the judge told him, you know, are you a U.S. citizen? Maybe. So be very careful with your immigration. This is a writ that was reversed. And that lawyer did fall on his sword, and he actually twisted it a little bit. He was pretty good. All right. Oh my gosh. This case is like totally bogus. It's like, what is the point? So his lawyer, I don't know whether he failed to convey the 10-year plea offer, or it was only, I don't know, but somehow the guy gets more time. He files a motion for new trial, and they're like, yes, your lawyer was ineffective for not conveying that 10-year plea offer. But then the state won't reoffer the 10 years. And so he wanted the judge to be forced to offer it, and they're like, no, the judge doesn't have to make them offer it. So, okay, your lawyer was ineffective, and you didn't get the benefit of the decade of time, but, you know, oh, what's the point? We're not going to force the judge to force the state to reoffer the 10 years. So that goes back to the ineffective about let your client know what the offer is. Okay, oh my gosh. I did not know, has anyone done these fraudulent use identity cases? I've never done one, so in reading it, I didn't realize that on a check, there's like 5 pieces of information you've taken, like their name, their driver's license, their address, the account number. So just 3 items, like he had a credit card bill, a driver's license, and a check, something like that, was like, it's like a ton of fraudulent possessing identifying information. And the court says item is ambiguous, but we will determine it based on the strict canons of statutory construction, and you lose. So just be very careful on those cases, because like there's tons of identifying information on just one document. All right, well, this one's a pretty good case. We'll see how it all ends up. But the guy's charged with, I don't know, killing someone or something like that. And he's in jail, and he says to some guys, he goes, well, you say that my co-defendant said he did it alone. And under the Code of Criminal Procedure, jailhouse snitches need corroboration. But they said, well, this wasn't really a statement against penal interest because he couldn't be prosecuted for that, although I thought they probably could. But the Court of Criminal Appeals said, no, that really was against his interest, even if it does not expose him to criminal liability. So the jailhouse snitch needed corroboration. All right. Just in case you wondered, this case, domestic violence, a result of conduct offense, this was a really long case about choking and whether choking, you know, it's the nature of the offense or the circumstance. They're like, no, it's the result. All right. Oh, this is, for those of you who really do worry about your jury charges on reasonable force and self-defense, it's really hard, I know, when you're like in trial to like decide what am I going to object to on this jury charge. You know, this is one of those things where the application paragraph was a little bit off. So I would recommend, this is just some appellate nerd, you know, recommendation, you don't have to take it all. Get that jury charge beforehand and see what they're going to put on it. You can Google it yourself and get the Harris County Jury Bank stuff. I like to do it and just look at it, see if there's any objections I can make. All right. Well, this was kind of a good case. He was convicted of, he was charged with felony murder, but they convicted him of the lesser of injury to a child. So typically, they would just sort of send it back for punishment, but in that circumstance, each of the culpable mental states has a different punishment range, so he got a whole new trial. All right? This is a case where they did the Batson challenges, like just between the judge and the DA in the back. And, you know, look, you weren't harmed by that. It's harmless. Because the only thing we talked about was neutral explanations. I can promise you, they were all neutral. So, you know, and that's a Supreme Court case. But it's interesting, this case, during the argument, it came to light that Mr. Ayala had been in solitary confinement for 25 years. And so Justice Kennedy wrote a big opinion about how tragic that was. I mean, you know, he's citing Dostoevsky. And then I thought it was interesting because then Judge Thomas responded and how, you know, the victims didn't have solitary confinement. They had no, you know, all sorts of stuff. But anyway, I think it's very rare if you read Supreme Court cases for them to write on anything that's not sort of the issue. So I thought that was good. Your right to a public trial can be waived if you don't object. So I would encourage all of you who, you know, have voir dire, get some of your pals to try and come in and let the bailiff keep them out. But you have to object, Judge. You know, we object. There's people that want to come. If you don't object, you've waived it. It used to be, you know, pretty good case law. Now you've got to really assert that right. Oh, and this is a case appellate attorneys really appreciate. You all, just be aware. It used to be, so you'd make all these great objections during jury selection, or objection, commitment question, or judge, they're denying me the right to ask a proper question, all those things. Then at the very end, when the judge said, do you have any objection to the jury, and you said no, that used to waive all your prior objections. All of them. Like, oh, well, you don't have any objections, which was completely bogus and ridiculous. And so Sterheim now says it doesn't necessarily waive it all. I would still encourage all of you to say something like, well, subject to my prior objections, I have no objection, or, you know, something. But you may or may not need to. And I know you're all not thinking like it might be a conviction. Sometimes that does happen, and I'm still in business. So anyway, be thinking about that. And the other thing, this is like totally off my paper topic. Please preserve some error in voir dire. It is one of the best areas for reversal. I kid you not. You can still get a reversal if they cut your time limits, if the judge says something crazy, which can happen. If you properly object to them not granting you a proper challenge for cause, please do that. And I'll be glad if you email me, I'll email you my paper on how to preserve error in voir dire. And I would just do that. Yes, Tom?
Don't forget to use all the strikes, ask for more.
That's right.
I got burned in
Well, and he's exactly right. You have to ask for more, and then if they give you more, what do you have to do?
Use them all and ask for more.
Ask for more. You have to ask till they won't give you what you want. Okay, that'd be good. All right. I just put this case, and more this is happening. This is a civil rights case from the U.S. Supreme Court. But basically, they show up, and I think it's a woman. She's severely having a mental breakdown. Of course, I think they tase her or shoot her or something. And they're like, well, aren't they supposed to, like, not do that? And, you know, well, but they still get immunity. You know, because they can't be expected to recognize that someone has mental illness and tase them at the same time. All right, sorry. Miranda, not you, Miranda, the other Miranda. So just booking questions are not an interrogation. So if there ever is a questionable one, like, were you driving the vehicle? That doesn't sound like booking. Money. Okay, if you're going to object to paying attorney's fees, which I don't think they do that much in Harris County, or court costs, you have to do it at the time you take the plea and not wait till you're adjudicated. And that goes for a lot of things. And have you all been getting your cost bills when your clients plead? I would like to tell you all too, do you know some of those costs you can ask the court to waive? Typically, most of them are mandatory, but many of them can be waived. And if you're aware of that and your client's indigent, even if he's going to prison, that money's taken out of their trust account. So I would encourage all of you, and I know it's a pain in the neck and people don't care, but money in prison is very important. It's the only decision an inmate gets to make as to what to buy in commissary. So if it's just going back to Harris County, and they don't need it. They don't need it at all. Right, Alex? They don't need that court cost. Anyway, so you got to make that objection. Oh my gosh, this is like groundbreaking. So you get a motion for new trial granted, and you think after 75 days, like, hey, you know, we're cool, we're done. But now the judge can rescind the motion for new trial at any time. So that just takes the DA haranguing him every day. Judge, you shouldn't have granted that. And then they're out to lunch. Judge, you know, that was wrong. Oh, okay. Because that never happens. The appellate timetable will start when he rescinds it. And they put that in the opinion. But I just think that's bogus. Don't you? Because if you want to do that, why can't I just harangue the judge for months to make him grant it? You know, it's basically getting a do-over on one side. And I object. I object. And I'm not sitting down. All right. This case, I would like to acknowledge that many people helped in the preparation of this PowerPoint because I make my office mates like summarize cases. This one's Scott Pope's. I used it exactly. But basically, they had a motion to adjudicate with some issues, then another motion to adjudicate with some new issues, but at the hearing, they went forth on the second motion, but used some stuff from the first motion, you know, and it's like, that's fine. Really? Because your guy screwed up, and he's going down. So you can make your objection, but think of something better than notice. All right. Search and seizure. Okay, this case blew my mind for many reasons. Basically, in LA, like the police can show up at any hotel and make them give this information. And I have this out so I can read it to you. The municipal code required hotel operators to record information about their guests. Name, address, number of people in the party, make, model, license plate of the vehicle